of honor. Yes, yes. You can start.
Okay, thank you, sir. Hello, everyone. I see Pallavi Agrawal from Lucknow. Delighted to welcome you all to today's webinar on this very timely subject on mediation for IBC Code and Companies Act. You will be hearing an insightful presentation from Advocate JP Madan and IPS Saurabh Bharadwaj. Today we have with us our guest of honor, Mr. Vikas Kumar, CEO, Caterer. Welcome, sir. We are delighted to have you with us.
Thank you, Pallavi.
Hanuman Jayanti is just a couple of days away. On 23rd April, we learned a lot from him from Ramayana. Being focused, Lord Hanuman had to face many distractions while flying to Lanka in search of Ma Sita. But he was focused on the goal of finding Ma Sita and he accompanied it. This Hanuman Jayanti, let's stay focused, ignoring the distraction, and we all will accompany our goal much faster. Here at JIPA, we try to create a learning environment for you. Here at JIPA, along with IBC Law, we try to create a learning environment for you all, where we learn together and reach new milestones. That is the beauty of learning. As a part of JIPA and IBC Law, we provide you with a timely topic and interesting speaker. We have come up with a weekly series of webinar. We had appreciate it if you interact and ask question at the end to our learned speaker and take full advantage of our weekly webinars. Before beginning of webinar, I would like to invite CA Praveen sir to welcome our guest of honor and all the participants.
Thanks, Pallavi. And we, on behalf of JIPA, most welcome to our guest of honor, Mr. Vikas Kumar, CEO of CADRER, and our guest of speaker, Advocate JP Madan, IP Saurabh Bharadwaj, and all the participants and our board members. In this regard, first I welcome to guest of honor, Vikas Kumar, the CEO, Center for Alternative Dispute Resolution Education Research, CADRER. He is MBA Finance, LLM Corporate Law, PG Diploma in ADR from ILI, New Delhi, DBA, PhD from SSPM, pursuing. Second one, 21 plus of professional, long working for NTPC Limited, KBUNNL, HURL, LG Life Sciences India, GM India, DS Group, visiting guest faculty for finance, accounting, GST and corporate governance to LIBA, Chennai, life member of ICDR, and more particularly delivering lectures to ICMA ADR chapter of commerce. In this regard, I most welcome to Vikas Kumar, and today topic is mediation and for IBC code and also for Companies Act. For Mediation and Conciliation Act, rules comes in Companies Act for as Mediation and Conciliation Rule 2016, which accommodates the mediation first of all, and then our IBC Board of India board framed a committee for organization of mediation in IBC code. And the committee reported to IBBI wide a framework on for use of mediation after the IBC code by expert committee constituted by the IBBI 31st January 2024. In this regard, first of all, mediation is more or first step to be in a dispute resolution mechanism, in my opinion. So this is the first step as the government has taken first step to accommodate mediation in IBC and Companies Act and other laws also, commercial law, etc. And with this regard, to go forward for mediation process, our learned speaker or guest of honor will elaborate deeply in the subject matter. We are inviting to Vikas Kumar, first of all, our guest of honor, to deliberate on this subject. Thank you, sir. Please welcome.
Thank you, Praveen sir. Thank you. Good afternoon to all of you. And today it's a very relevant topic we have, and we have a very august audience before us. And obviously, we have a very learned speakers who will definitely throw the light on the nitty-gritties with regard to the IBB and Companies Act and all, being a domain savants and experts, what they have been doing. So we know that mediation is a very pertinent topic today, and since it is not a new one, we know that it has been there in a since a time memorial, and it has been very effective tool. We all know that, being a practitioner in our own domain, so we know all the significance with regard to the mediation. So we know that the government in India, actually, we are most of the time we know that what is the economic efficacy of our country. Being a developing nation, we always follow what the other developed nation has given the efficacy with us. So just to keep pace with that, we know that in an international domain also, mediation is surpassing the arbitration as such. So now in India, actually, we have a peculiar situation wherein we have a mediation and conciliation having two separate enactments, as we all know that. However, in the same year in 2023, when we have mediation were just replacing their arbitration and conciliation, saying arbitration and mediation. So the very efficacy of mediation is very effective. We know that it deals with the crisis, and the business fraternity. They come, across the globe. They don't want to get stuck with a jurisdiction as such. So they want a very hassle-free ecosystem wherein they can, flourish. And from an investment point of view, the other aspects of the business, it's getting addressed by the world community as such. So thereby a most effective enabling ecosystem is required. And we know that how IBC is there in place, how Companies Act with bringing in the all stringent governance norms into that. So all such whatever provisions that has been incorporated in light of those imperative that as a country we have. So, but the very underlying aspect is that whether we have a law practitioners also, we have a finance practitioners also, we have a practitioners from a different specialized field also, they must understand that none of the enactments, none of the efficacy would go antithetical or go inconsistent with the established fundamental structure of our sovereign
Can you
interest.
speak louder, please?
Yeah. Now I am audible.
Yes, sir.
Yeah.
Please.
This is there is an interplay of such enactments that we are having to deal with a specialized kind of issues that we have. So as you know that the very bottom line is that we have to work in the in the development of the ease of doing business, the very reverberating object that as a country we want to try to make this country as a most favorable place for investment and for business. So because of that only, to give a very world class ecosystem to survive here, what they have been, so this enabling ecosystem is coming as a matter of challenge before us. So last almost a decade, our government is making all possible efforts to bring it up with regard to the all such things. So mediation is such a tool which requires to address the issue before it comes to the domain of crisis. Okay, so now in corporate, we all know as a practitioners, we all know that we all are learned representative of our own respective domain. So we understand that now we are at a very nascent stage to bring in the mediation into this insolvency domain, wherein we know that there is a process for a easy exit. The ultimate object of that is to bring in the easy exit for the respective stakeholders, keep without repudiating the sovereign interest. Because you know that why cryptocurrency is not getting the acceptance from the all jurisdiction across the globe, because the only fact that it has world best class technology, everything is there, but the only thing is missing is the reverence of the sovereignty, okay, interest, which is missing into that. So because of the fact that it is repudiating that very aspects, thereby it is not getting acceptance from the jurisdiction, even from the developed nation. Okay, so similarly it is coming as a matter of challenge. So we know that we have an enactment called mediation. It has its own all provisions are already being given. but I'll discuss the most fundamental aspects which will clarify the de jure and de facto proposition with regard to this kind of resolution through a ADR mechanism. And we know that mediation is one of that. So in mediation, when we talk about interplay with other things, then we have to see that how it will be more effective into a a de facto mode. So for that sake, we need to understand the applied proposition. So we know that in an insolvency, there are stages involved into that. And in all stages, as you know, that committee in 2023, the expert committee has given some recommendation with regard to that. So the very fundamental aspects which is appearing to a mediator, or the very precepts of mediation, is that it appears antithetical that you cannot force mediation to anyone. However, in India's, for decades, we have been seeing that there will be a court annexed mediation or court directed mediation is there. But mediation is a subject matter of voluntary. You have to respect the voluntary aspects of, looking forward to resolve the issue by the party itself. However, all ingredients are already being incorporated into these kind of efficacy, wherein the all party autonomy and all aspects are already been incorporated. But when we deal with the insolvency, wherein the matter is already to the domain of crisis, and it is coming or emanating out of the conflict as such, so there are all procedural aspects has already been attached to the NCLT and all such things similar to the court of law. So, but the very fundamental things at the very beginning, at an international level, whatever enactments you are bringing, whatever enabling ecosystem you are developing or evolving, it has to respect the very precepts that they have, the fundamental precept they have, that minimum judicial intervention into that. They don't want to get into, struck into these kind of different jurisdictions proposition wherein they have a problem into that. So mediation is coming as a remedy, you would say that, wherein it would get interacted in the Companies Act also, where it is in section 442, it has been given a provision and given a space that they have, but for that sake, in India, we need to have a capacity building. We need to work on that on a massive scale, which is missing as such. Because mediation is something, it is not a kind of thing wherein you can have a exporting things and then you can do it. You require some very soft skills into that, and you need to enable the entire efficacy and entire procedure of resolving the issue by the party itself. So it is almost like succoring, supporting, facilitating, or enabling, melting of a cold butter. Okay, so this is something which is very delicate. Okay, a very sophisticated one has to apply that. So when we deal with the subject of mediation, then I presume, to my mind, we are attaching, or we are looking forward for the interplay that there with the IBC and all those things. We are actually visualizing a scenario, a court annexed mediation kind of thing. So we are looking forward, or maybe we are imagining a situation wherein such tribunals annexed mediation would be there to address the issue. But ultimately, it is primarily, it is going, inconsistent with the very precepts of the mediation. That is what the voluntary aspects. So you are asking the parties, though they are voluntarily not agreed to, even to first meet with this kind of mechanism, then come to the floor of the tribunal as such, and then against this entire efficacy and entire edifices will be there in place to follow. So these aspects are already attached with that, and I will definitely try to address the applied aspects which is coming in between, wherein at what stages how mediation can be more effective, and how it can introduce into that. That is becoming a matter of challenge, because at a place wherein you have to take care of the scenario, wherein you have to see that it should not be repudiating any of the fundamental precepts of the sovereign jurisdiction that we are having. Like, in other words, we can say that none of the aspects will be going which is not within the four corner or within the mandate of the mediation as such. Like, it's not any issue which is not to be mediated, which in other words, which cannot come within the domain of the mediation, which is very perspicuously delineated in the Mediation Act 2023 itself in Schedule 1, wherein what those aspects will not come into this domain of mediation. Okay, so such things we have to take care of. The practitioners have to take care of that, how to enable that. And the other aspects, which is also a very prime concern for the committee, that they have given a recommendation that in addition to go for a capacity building, and I'm very thankful to GIPA that GIPA that they are bringing this kind of say webinar and this kind of gatherings, wherein they are really doing a very commendable job to enhance the awareness with regard to the mediation, which is coming into the domain of this kind of dispute settlement and dealing with the crisis that we are having. So such kind of proposition is very much required, which are very much asseverated by the government as well. So therefore this is required, and this is something wherein we are already expert into the respective domain. But here the thing is that the very peculiar proposition with the mediation is that you cannot suggest the solution to the party as such. Otherwise, it will be simply infracting of the very precepts of the mediation law itself. So you only enable the parties to bring to the solution, come to the agreement of this as a matter of solution to their disputes. Okay, so for that sake also it is required that parties should also be very much aware with regard to that, instead of getting compelled or what is imminent out of the given efficacy or any structure of enactments and all those things. So it should not come as a matter of imperative on the part of the parties, because that is going to frustrate the entire objective of having this kind of ecosystem in any jurisdiction as such. Okay, so in other jurisdictions also people are preferring mediation, and then because of that very factor, these jurisdictions on international level also, they are very much concerned that how to invoke this particular proposition into this kind of things. And it will only happen when the all parties are equally aware with the very efficacy of this kind of mechanism that is there in place with the help of the enactments. And we must also thank to the judiciary that after in 1996 act came, it was a commendable by the government, and because of the judicial intervention, okay, right from the Balco case and AFCON case and other cases until today, we have Vidya Drolia cases and all such cases, we have ONGC cases. So these cases, by virtue of that, this ADR mechanism have got strengthened. So we much thankful to our judiciary also. We had amendments in arbitration acts also, and then we have come to this far of having a mediation act last year. So these mechanisms are very much required in all domain wherever there is a dispute coming or emanating out of the business proposition or contractual propositions. So these aspects must be encased or recapitalized by each of the stakeholders. But it will only possible when we have a very enabling environment. We have to create, and we need such kind of programs, such kind of things what GIPA is doing today. Because when we sit with a mediation, we see that more than 60% cases comes to us wherein we have to give a consultancy that look, your case is not amenable to the mediation or arbitration as such. So this is sometimes, see, they but they insist, no, we have to go that, but they have to understand the very proposition of the particular enactments, wherein the very limited scope is there after having these kind of things. Okay, I am just deviating for a moment to give you to have a better understanding that how these things has been given a mandate not only by the legislature, by the judiciary as well, that you have a very limited scope for further litigate on that matter or further drag this into the domain of the court of law to have further decide or appeal. Like in arbitration, we have a section 34. So you have a very limited scope to go after arbitral award and all such things. So in mediation also, since it is a very voluntary aspects, there is no binding on the parties, those who are mediating, to go there whatever they are agreed to. But now the environment is coming wherein they will agree to that, and it will become an agreement, and it will be enforced as it is enforceable things what is happening under the contract act, which each of one of us is understanding what is a very fundamental precepts which is driving the entire discourse. Okay, having a different enactments, but the very precepts are the same, premises are the same. On that very premises it will go. So as a practitioner, again, we come across a situation wherein we have to see that what to opt when we come to a crossroad wherein we have a specialized enactment with us, and at the same time we want to invoke this kind of ADR laws into that. Okay, so there we have to see that then a situation of doctrine of equity and rule of law comes into play. So we have to always be clear on that part, that always if there will be any conflict into that, we know that very fundamental aspect is there, that we have to go by the rule of law, that will prevail over the doctrine of equity as such in the practice. That usually happens. So what is happening in a insolvency domain, how corporates are coming into a situation, into a crisis, and they want a very legitimate, bona fide, structured, systematic way of dealing with the issue, wherein the all stakeholders will be having a very amenable situation to depart from there. But ultimately it's not a depart for a good, not for good, it is not a permanent departure from there. So these propositions, the domain experts will deal with the subjects. I know that there are n number of cases. There are a katina of judgment that has come, that has deal with a very fundamental applied proposition, wherein the rule of law has to be applied on the basis of the efficacy of the subject, wherein they have to decide. Then we have a limitation law as there. Then we have to go by the time frame given into that. So these efficacy, what is very much attached concomitant with the subject, one must have to follow this. And because this is something which is acceptable across the globe, and ultimately we have to do that. But we have a contrast into that also. There are scenario in economy wherein you have an enactment dealing with the subject, and then again we have a enactment dealing with the respective domain of that. When there is an interaction happens, now the point comes to our mind as a practitioner, that what to suggest there, which law will prevail. We know that there has been a cases wherein the court of law has given a clear cut mandate that what is the jurisdiction with regard to this enactment, specialized enactment, and the intervening enactment out there. So these very precepts as a practitioner we must follow, and we have a n number of examples leading to the conclusion that ultimately this efficacy are requirement of the day, because of the fact that the structure that has come as an alternative, as a tribunal, or giving a solution to that on the very reverberating objective of the government or the jurisdiction, as an imperative of the global covenants and all. So we have to respect that, and we have to bring into the system. And I hope that our domain servants and experts will definitely deal with the IBC issues. What I am deliberately not touching, how these disputes happen, how different stakeholders, right from the corporate debtors and all aspects, how what their interests are, how they sometimes. I have seen one of the cases wherein a party was deliberately trying to make use of these provisions because they were very skillful into that. Okay, but that very domain, that very industry was getting frustrated because of that. So the industry representative was trying to indirectly intervene into that to safeguard the industry perspective. Sorry, someone was. Okay, so this is something which is very important. So there is a very important interplay. We are at a very initial stage to respect the global phenomena, global affairs. We need to further strengthen this entire proposition. We should, reciprocate the mediation law, bringing into this IBB at a different stage. We have to identify the, contour of their interactions, and accordingly, we must promote these aspects to have it. So from my side, I think I am going by the time. I am not taking much time of it. So I'll request the Pallavi ma'am to please take over. In case any requirement will come in between, I'll definitely will love to deal with the very applied aspects as such. Thank you. Thank you.
Thank you so much, sir. With such a deep deliberation on the topic, I am sure now participants have already developed a keen interest on the topic.
Yes.
Moving further, I would like to introduce our first speaker of the day, Advocate JP Madan sir. He is a registered insolvency professional, managing partner, Madan Law Office, chairman at NCLT and IBC committee at PSG Chamber of Commerce and Industry. He is an alumnus of Sri Ram College of Commerce, Delhi University. He handled more than 100 cases under IBC and acted as a legal counsel and advisor to many corporate debtors, financial creditors, and operational creditors. Welcome, sir. I am sure our audience will greatly be benefited with your experience and insight. Now, floor is all yours, sir. And thank you, sir, for the
Thank you, Pallavi. Thank you. Good afternoon, all. Hope I'm audible and visible.
Yes, sir, very much. Thank you.
Thank you. First of all, my compliments to Mr. Vikas for what a mesmerizing introductory talk. The wonderful.
Thank you, sir.
And then my compliments to Mr. Praveen and the entire team of JIPA. During the day, I was talking to Mr. Praveen. मैंने ऐसे ही उनसे पूछा कितने रजिस्ट्रेशन है, बोले 60 प्लस है. मुझे लगा शायद प्रवीण जी ने मुझे खुश करने के लिए कह रहे हैं 60 प्लस है. But I'm really pleasantly surprised to see that attendance is 60 plus right now. On this Saturday afternoon, when number of events throughout the country are going on, presence of 60 plus participants on Saturday afternoon, it's a commendable job, and it talks of your efforts, Parveen ji, and your fan following also. Now, coming to today's talk, role of mediation in insolvency, particularly with respect to the report which has been submitted by the committee on 31st of January 2024, and Mr. Praveen had discussed about that report in his initial remarks. Friends, what exactly is mediation? We need to understand that. It is something new. According to me, no. Day in and day out, we all play this role. And sometimes we are party to this mediation. Whenever an accident happens on the road, दो कारें आपस में भिड़ गई, एक कहता है तेरी गलती है, दूसरा कहता है तेरी गलती है. In the meantime, traffic police comes. दो ही ऑप्शंस होती है ट्रैफिक पुलिस वाले को, या तो आज साइड में आ जाओ और विल टेक यू टू द पुलिस स्टेशन. तो या आप साइड में आ जाओ या पुलिस स्टेशन चले जाओ. दोनों ही केसेस में 99% ऑफ द केसेस में दैट पुलिस वाला, दैट पुलिस ऑफिशियल plays the role of a mediator. He simply advises both the parties not to insist on filing an FIR. Please यहीं settle कर लो. उसी में सबकी भलाई है. And that is what we do. At that point of time, that police official is mediator, we are parties to the mediation. Many a times we have seen the disputes between husband and wife. No point of return. File a divorce petition. Go to the court. सौरभ जी, आपका शायद माइक ऑन है. मिस्टर सौरभ भारद्वाज.
Sorry, sir.
No issue. I think you want to say something. Okay. So at that point of time, what the court does, court refers the matter to mediation center. The first attempt of the court is also to send the matter to the mediation so that if possible, अगर mediation से बात बन जाए तो issue resolve हो जाए और family बच जाए. Because impact of this divorce is very, very negative on almost not only these two entities, but on other many individuals also. Thirdly, because I have been practicing in insolvency and in Companies Act also for last many years. Section 397, 398 petitions under Companies Act 1956 and Section 241, 242 petitions under Companies Act 2013. What exactly is there? The two factions of shareholders. One says the other is suppressing me. The other is taking actions without taking me into confidence. The other party is avoiding me. The other party is siphoning off the funds of the company. Other party is opening the bank accounts. Other party is placing the orders. Other party is appointing the auditors and not allowing me to take participation in the functioning of the company. Many a times when these matters are before the court, earlier before Company Law Board and now before NCLT, and these matters take not only months but years together. 3 years, 4 years, 5 years, 6 years, 7 years, 10 years, even some of the matters which were pending under Companies Act 2013, under 397, 398, they are still pending before NCLT now, after the matters have been transferred to NCLT. So what exactly is happening in these cases also? The courts are trying their level best. The courts are trying, what the courts are saying, okay, valuation करवा लो, ऐसी valuation करवाओ जिसपे both the parties should be ready either to buy or sell. But somebody has to sit in between the two parties. Many a times, friends, can you believe it? These 241, 242, 397, 398 matters have been resolved in my office. Both the parties are sitting and the auctions are happening on the basis of the available valuation. And invariably in all these cases, friends, I normally speak against my profession. I always advise the client to resolve through mediation. It's better to resolve at the earliest, better to resolve before filing of the petition or maybe at the initial stages of the petition. Because ultimately these issues will be resolved through mediation only. Both the parties will have to sit across the table and resolve all these disputes. अगर 10 साल बाद ही बैठना है, 5 साल ही बाद ही बैठना है, तो आज क्यों नहीं बैठ जाते? Because in the meantime, nothing is going to happen. The assets of the organization are going to deteriorate, and it's the lawyers who are going to earn at your cost. The choice is yours, whether you want the lawyers to earn or you want to live a peaceful life and along with that earning also. So invariably, the mediator has to play its role and both the parties should be subject to mediation. So what exactly is the crux of the mediation? हिंदी में अगर मैं कहूँ तो बात करने से बात बनती है, लेकिन प्रॉब्लम क्या होती है जब दोनों पार्टीज इस स्टेज पर आ जाती हैं कि बात ही ना हो पाए, तो इसलिए वो बात करवाने वाला चाहिए बीच में। दोनों पार्टीज को कौन बिठाए, दोनों पार्टीज को कौन बात करवाए? तो ये जो बात करवाने वाला जो है, और बात करवाने वाला कौन होना चाहिए? दोनों पार्टीज की कंसेंट से, जिसको दोनों पार्टीज एग्री करे कि यस, इस मीडिएटर को, इस बात करवाने वाले को हम सुनने को तैयार है, मानने को तैयार है नहीं, वो बात की बात है, सुनने को तैयार है, क्योंकि मानना ना मानना, नोबडी इज बाउंड टू मानने के लिए, बट एट सुनने को तैयार हो जाए। एंड नॉर्मली इट हैपन, जब सुनने को तैयार हो जाते हैं और दोनों पार्टीज को मीडिएटर की बात अच्छी लगती है तो दोनों पार्टीज मान भी जाती है। This is what mediation is. Now, what is the role of mediation in insolvency? I remember the year 2020 when my son, who is there in the US, he conducted many webinars at that point of time on mediation with insolvency, because my son is dealing into international arbitration there. So he conducted many webinars on mediation with insolvency, and the participants and the faculties were from across more than 50 jurisdictions in each of the webinars. At that point of time, I thought, when in a global jurisdiction, this mediation is there in insolvency cases, why can't the same be applied here in India? And when I applied my mind, so I came to the conclusion that mediation already exists in our insolvency cases. It's nothing new. Only thing is that we have not given the name mediation to those instances, but actually mediation is already there. Friends, if you see this report also, which has been submitted by the committee to IBBI on 31st of March 2024, that report very clearly says that under CIRP, so far 3.2 lakh crores has been recovered by the claimants or by the lenders. But at the same time, after initiation, but before commencement, it means after filing of the application and before admission of the application, 26,000 applications have been withdrawn. On what basis? On the basis of settlement between both the parties. And the underlying amount in this 26,000 application was to the tune of 9.2 lakh crores of rupees. Imagine this figure. Under CIRP, approximately 3.2 or 3.3 lakhs. But under these settlements, prior to admission, 9.3 lakh crores. Mind-boggling figure. अब ये एप्लीकेशन डालने के बाद और एप्लीकेशन एडमिशन से पहले अगर कोई सेटलमेंट हुई है, डोंट यू थिंक कोई बीच में कोई ना कोई बैठा होगा? डोंट यू थिंक किसी ना किसी बीच में मीडिएट किया होगा? डोंट यू थिंक कोई ना कोई होगा वहां पे जो दोनों पार्टीज को इस कंक्लूजन पर लेके आया दैट इट इज इन द इंटरेस्ट ऑफ बोथ द पार्टीज दैट दिस एप्लीकेशन इज विथड्रॉन, and it's not in the interest of both the parties but also in the interest of the particular corporate debtor, its vendor, its suppliers, its employees. So it's in the interest of so many stakeholders that his application gets withdrawn and both the parties settle. So it means mediation has been playing its role for last 7 years since the time this legislation has become a reality. But now the government wanted that there should be something so that this mediation can be given a legal framework. Earlier, friends, the mediation was not having any legal framework at all, what to talk about insolvency otherwise also. Therefore, last year, the government also came out with a legislation called Mediation Act 2023. Taking a cue from that, simultaneously, IBBI also decided that let's do something as far as mediation is concerned. When it was seen by the stakeholders that many matters are taking years together before Honorable Adjudicating Authority, sometimes admission is also not being taken for years together. And post-admission, the CIRP is taking years together. The implementation, then there are certain disputes at the implementation stage also. And everything cannot be part of the legislation. Each and every hypothetical situation cannot be considered in the law while framing the law. Therefore, the government thought of to begin with, that let there be mediation be introduced at all stages of insolvency, at all stages of CIRP, pre-CIRP, pre-admission, post-admission, and during implementation. Keeping this objective in mind, the government constituted a committee and the committee gave its report to IBBI. Now, what exactly is there? And one more thing, as you know, whenever we talk about IBC, we talk about delays, and for every delay we say, no, it's the NCLT which is responsible for it. That is absolutely wrong. It's the entire system which is responsible for this. Do you think when we had IBC in place, did the government think of that all the real estate matters will be part of IBC? Answer is no. Did the government think that in one application, there will be 50 to 100 IAs pending? And each IA is a separate case in itself. And unless these IAs are decided, the final application, resolution plan application cannot be decided. All this situation was not envisaged. So therefore, to reduce the burden on NCLT and to keeping in mind the speedy implementation of the entire process of CIRP, because speed is the hallmark of this particular legislation. So keeping this thing in mind, the government decided let mediation be introduced in IBC also. So with this objective, this committee was constituted and the committee gave its report to IBBI. Now, what exactly is there in this report? Maybe in next 10 minutes or so, I would like to highlight what exactly is there in this report. Because at this stage, this is a report only. On the basis of the report, tomorrow we may have regulations, and these regulations, when implemented, at that point of time, these will see the real impact of those revised regulation and the impact of this particular report which has been prepared. First of all, this report says that Mediation Act actually is, what do you call that? Everything fits into one particular framework. But government, IBBI particularly, does not want, the members of this committee do not want that IBC, this particular mediation framework within IBC, should fit into the mediation legislation. We need some sort of flexibility. So therefore, it has been said that Mediation Act per se will not be applicable to these mediation proceedings. However, wherever it's possible, we take a cue from Mediation Act, but per se Mediation Act will not be applicable to these mediation proceedings. So it means mutatis mutandis, wherever the changes are possible, the changes shall be incorporated here. So what has been proposed in this report is that there should be introduction of mediation as alternate dispute resolution mechanism. And actually mediation is ADR, only one of the branches of ADR. Then another recommendation in the report is delegation of authority, rather delegation of power to be given to IBBI to frame regulations and to Ministry of Corporate Affairs to frame rules for the purposes of implementation of this mediation mechanism under insolvency. So this is the proposal, the rule making authority to vest with Ministry of Corporate Affairs and regulation making authority to vest with IBBI to make regulation with respect to mediation, right? Then further, there is a provision that there's who shall have the database and who shall have the secretariat with respect to mediators and mediation. So there it has been proposed that it shall be NCLT, the adjudicating authority, not IBBI. Tomorrow in the regulations, we may see that IBBI is having database of mediators while the secretariat it has NCLT. But these things are yet to be decided because, you know, these mediators, who can be mediators, I'll come to that in a while, because mediate not only insolvency professionals, but whole lot of other professions can also become mediators. So whether the IBBI would like to have control or jurisdiction over these mediators, or they shall be within the domain of NCLT, that is yet to be decided. But the secretariat to remain with NCLT only, this is what the proposal is. Then it has been said that there should be specific timelines for this mediation. And the timeline which has been proposed is not exceeding 30 days for the mediator from the date of reference of matter to mediation. And why 30 days have been prescribed? Because the government does not want that overall framework of CIRP, that is 180 days, 270 days or 330 days as the case may be, that period should be prolonged. No. Government wants entire CRP process should be conducted within this timeline, 180, 270, 330 days. And out of this 30 days should be dedicated for mediation. Now the issue is whether this 30 days shall be excluded or not. Normally we see the adjudication period gets excluded. We have yet to see the regulations with respect to this. Government is to decide whether the 30 days shall be excluded or not. Then the another recommendation is recognition of and enforcement of this mediated settlement agreements. Friends, so far the outcomes of mediation are not binding as far as the practice is concerned. But whenever there will be any mediation under IBC, there shall be an agreement, mediated settlement agreement, in short it's called MSA. Now it has been proposed that this particular agreement should be recognized and should be enforceable. Now this is a very, very major task. It's not an easy thing, that mediation settlement to be, because then certainly you have to distinguish between mediation settlement agreement as well as arbitration award. Is there going to be any difference or not? According to me, there has to be some difference. But if this mediated settlement agreement is recognized, if it is enforced, it may have the same sanctity as of arbitration award. But the question is, can any appeal be filed against this MSA? My answer is no. This MSA shall not be appealable because this MSA has been arrived at after taking the consent of both the parties. When both the parties have consented to this MSA, then certainly no party will have a right to file an appeal against this MSA. So that way, to that extent, we cannot equate it with arbitration award. But from enforceability point of view, certainly it is as enforceable as arbitration award is. So that's a very, very good thing which has been proposed by this committee. Then, as I said, that there are rule making power and regulation making power. Now, at pre-initiation stage, this mediation facility shall not be applicable to applications to be filed by financial creditors. Per se, it will be applicable, it will be available only to applications to be filed by the operational creditor. So FCs will be out of domain. No settlement with FCs at this stage. But at this stage, mediation is allowed whenever the applications are going to be filed by the OCs under Section 9. Okay. Regulatory framework. IBBI shall frame regulations with respect to what? With respect to conduct of mediators. Like IBBI conducts the role of conduct the the insolvency professionals, all the intermediaries, they are being governed by IBBI regulations. So that way, IBBI will be governing through regulations these mediators also. Then, how a mediator to be appointed or to be removed, all that also shall be part of the regulations to be framed by IBBI. Capacity building program for mediators, like capacity building programs are there for the insolvency professionals or the valuers also nowadays by our respective regulator, whether it's IBBI or IPAs. Similarly, our Praveenji is also having this capacity building programs, and today is also one such capacity building program for insolvency professionals. So similarly, capacity building program provisions shall be there, mandatory provisions shall be there from IBBI for mediators. And then how to enforce this MSA? Regarding that, IBBI also, the committee says that IBBI should frame the regulations. Now, the question is, should the mediation be voluntary or on the recommendation of NCLT? Under Companies Act, whenever there is a dispute, both the parties, if they consent, or maybe NCLT also may ask both the parties if they are agreed to the mediation, NCLT may refer the matter to mediation. And then regional director is having a pool of mediators. But here, so far the proposal is if both the parties are in agreement, they can go for mediation. And NCLT has no authority, no power to refer the matter to mediation. But according to me, this provision may be there tomorrow in the regulation that on the consent of, or subject to the consent of both the parties, NCLT may refer the matter to mediation. I'm very confident this provision will be there. No, at what stage matter may be referred to mediation? As I said, pre-initiation only OCs. But after admission, or maybe post-initiation but before admission, at that point of time also, according to me, the mediator role is there. Whether it's a Section 7 application or Section 9 application, because Section 10, according to me, is out of the purview of mediation. Somebody is asking a question, is there any provision to take grant permission to IBBI? Sir, today there is no provision at all. Today there is a report and there is a proposal. All these are proposals which have been given in the report by the committee to IBBI. Today there is no provision. We have to wait for the fine print, which shall ultimately be thrown open to the public, to all the stakeholders, particularly the professionals, and we will have right to give our recommendations to the government, to IBBI, and on the basis of that, the final regulations will be there. Okay. The third stage is after CIRP commencement. At that point of time, Many a times it is happening nowadays that because of these IAs which are filed post admission, the matters are getting delayed. Now, to reduce that pendency, to reduce the number of those applications, actually that is nothing but leading to litigation. To reduce that litigation, now there shall be provision for mediation at that point of time, either after filing of the IA or before filing of the IA. Because somebody is raising an issue before the COC, and COC is of the view, let this matter be sent to mediation. So at that point of time, the mediator may be there and both the parties are sent to mediation so that there is no new IA. If there is a IA, then certainly there will be IA, there will be reply, there will be rejoinder, there will be arguments and blah, blah, and all that. It is again going to derail the CIRP process. And the next stage of mediation is post approval of the plan during implementation. At that point of time, friends, many a times we see there are disputes between the stakeholders and the SRA. Dispute between the SRA and the government authorities. Dispute between the SRA and the statutory authorities. To reduce all those disputes, again, now there will be provision for mediation so that implementation of the plan does not get hampered. So with this intention, there are provisions in the report also. We'll have to see the final print when the regulations are prepared. Now, there is also a proposal of having this mediation at the time of pre-pact. Pre-pact, friends, unfortunately has not seen light of the day. Hardly a few number of cases are there in pre-pact. And I wish even our finance minister is also worried that PPIRP has not become a reality so far, and on basis of recommendations of the stakeholders, only PPIRP provisions were introduced. But in practical, these PPIRP provisions, not many cases are there under PPIRP. Then there is a provision for mediation in cases of PG to CD, because that's a new field which is now opening after the Supreme Court judgment. Now a number of cases are being admitted, a number of PGs are being sent to insolvency process, and RPs are being appointed in those cases. But many a times it is happening, friends, we see that those personal guarantors are not having any assets. So if the personal guarantors are not having any assets, if at that point of time, whatever the assets are available, so instead of lengthening the process, taking a lot of time in this insolvency resolution process of the personal guarantor, it's always advisable to have some sort of mediation, and whatever is being offered or whatever is being accepted by the lender, I think the issue should get closed there only with the help of the mediator. Then friends, as I said that NCLT, when NCLT will be having a provision for the secretariat, at that point of time, NCLT will have to have a provision for, like we have arbitration centers in Delhi High Court and many other places in various chambers of commerce also. You have to have these mediation centers in NCLT. आज की डेट में अनफॉर्चुनेटली NCLT के अपने स्टाफ के पास बैठने की भी इतनी जगह नहीं है, और हमारी own NCLT Delhi is also looking for a bigger and better place with having better infrastructure. Same is the situation in almost all NCLT benches, barring couple of NCLT benches, they have adequate space and excellent infrastructure. So unless these NCLT benches are having the best of the infrastructure available, according to me, these mediation provisions cannot be made applicable. Because NCLT will have to provide the secretariat, the place, the mediation centers, the e-meeting facilities, e-voting facilities, and e-filing. So there will be a separate filing process also for this. So unless even आज की डेट में हमारा अपना filing ही कभी और इतना delay हो जाता है. Today only I was reading in one of the groups कि NCLT का e-filing mechanism जो है जो इतना अच्छा हुआ करता तो इतना खराब हो गया एकदम से. So unless we have this existing setup to the best of, to the maximum possible, whichever desired by the stakeholders, unless NCLT and NCLAT are having this best of the infrastructure, this mediation infrastructure cannot be provided. And in absence of infrastructure, any commencement or any new regulation with respect to mediation will again be, friends, disaster. Now I'll come to, though there are other issues to be discussed, but looking at the time constraints are there. Who can become mediator? You and me, friends, first of all, both of us can become mediator. The retired member of NCLT and NCLT can become mediators. Senior advocates can become mediators. Advocates having 10 years of practical experience can become mediators. Any individual having experience in resolving insolvency matters, whether advocate or not, can also become mediator. Retired government officials having experience and expertise in this can become mediators. And persons with technical expertise in insolvency, accounting, valuation, and industry operations, all those individuals can also become mediators. And last but not the least, friends, a code of ethics shall also be there for the mediators. Friends, as on date, we see many times we see in adjudicating authority and in appellate authority, strictures are passed against insolvency professionals. Adverse observations are there against insolvency professionals. Today, I've seen one press clipping. What the press clipping has done, they have compiled all the disciplinary orders of last 3 months from the IBBA website and have incorporated all those issues in one press clipping. That how many actions have been taken against the insolvency professional, what is the conduct of the insolvency professionals. That actually gives a bad name to our profession. And in turn, when a question was asked to one of the insolvency professionals, what do you say about the insolvency, this disciplinary action against you? He has given a reply to that press person that what is the qualification and practical experience of that particular official who had taken this action against me, who is sitting in IBBI. So that way, this highlighting of these matters in the social media or on the hosting of these orders on the website also, I think we should also make a representation to the government, to IBBI, that these orders should not be posted on the website of IBBI. Actually, it gives a bad name to the entire profession. Because if you see those cases, it's not that IBBI, those cases have been decided on merits. When there's some of those writ petitions are filed against those insolvency professionals, many times you see that these orders are set aside. In number of cases, we have seen these orders are getting set aside. So why? And recently the Bombay High Court judgments on 4th of April in Amit Gupta matter. What he said that why IBBI should suspend AFA when the moment this SCN is issued. AFA cannot be suspended at that point of time. So IBBI should reconsider this. So that way, friends, this code of ethics, which shall be prepared for the mediators, we all shall be bound by that. But at that point of time, I think the lenient approach should also be taken by the regulator. But friends, I tell you, being insolvency professionals, and I'm considering that all of you are insolvency professionals, or most of you are insolvency professionals, it's a golden opportunity for all of us to be mediator. Don't wait for the rules and regulations. Don't wait for any legislation to come. Start mediation immediately. You have many opportunities. During your CIRP, you can act as mediator. As a resolution professional, आप जब COC मीटिंग में बैठे और वहां पे आप देखते हैं किसी तरह कोई झगड़ा होने वाला है, होने से पहले बचा लीजिए, एक्ट एज मीडिएटर. आपको लगता है कोई एप्लीकेशन फाइल करने वाला है NCLT में, रोक लीजिए वहीं पे, एक्ट एज मीडिएटर. उसके लिए यू डोंट नीड एनी प्रेस्क्राइब्ड क्वालिफिकेशन, यू डोंट नीड एनी रूल्स, यू डोंट नीड एनी रेगुलेशन. और अगर आप ये काम करते हैं और इसमें सक्सेसफुल हो जाते हैं, आई टेल यू, ना तो आप NCLT के ऊपर बर्डन कम करेंगे, बट इट विल लीड टू बेटर रियलाइजेशन. इट विल definitely add to your economy, the economy of the country, as well as it will also lead to self-development. So it's a win-win situation for all of us if we act as mediator, not under insolvency law, but in all our professional spheres wherever we are. Thank you so much, and thank you, Praveen ji, for giving me this opportunity.
Thank you so much, sir. It was really very, very, very insightful. आपने सब कुछ बहुत elaborately करा, सारा टॉपिक में हम लोगों को डीपली समझाया, क्वेश्चंस भी लिए, सजेशंस भी दिए. Now moving ahead with our next speaker of the day.
पल्लवी जी, अगर नेक्स्ट स्पीकर से पहले अगर कुछ क्वेश्चंस हो, 2-3 अगर अर्जेंट कोई क्वेश्चंस हो, एंड कैन टेक दोस
सर
क्वेश्चंस.
2 क्वेश्चंस हैं, एक लेकिन ठीक है, एक
नहीं, पर सबसे पहले आप सौरभ जी की पहले कंसेंट ले लीजिए क्वेश्चन लेने से पहले. अगर सौरभ जी को एग्रीमेंट तब मैं क्वेश्चन लूंगा, नहीं तो नहीं. आई विल नॉट ईट इनटू हिज टाइम. सौरभ जी आप म्यूट पर है प्लीज. सौरभ जी, यू आर ऑन म्यूट.
Sir, mine is of very short duration. Please go ahead.
नहीं, ड्यूरेशन की बात नहीं है ना. मैं देखो, आपके पहला राइट आपका है.
No, please, sir, please. It is enlightening to hear you, sir.
थैंक यू. हाँ जी पल्लवी जी.
सर संघर्ष वाघ ने लिखा है whether 10 years experience is mandatory.
What is mandatory?
सर मीडिएटर बनने के लिए क्या 10 साल का एक्सपीरियंस जरूरी है?
As per the proposal, yes. Or unless you have some sort of experience. वो 10 साल उन्होंने सब जगह लिखा है. अभी प्रपोजल में है ये. आप ये देखिए ना, 15 साल का तो हम सबको एक्सपीरियंस हो गया, 20 साल का. तो वो 10 साल तो ऑलरेडी निकल चुके हैं. All of us are eligible to become mediators. Don't worry.
Yes, sir. Sir,
you know whether you have worked as a chartered accountant, a lawyer, or practicing company secretary, or whether you are headed a legal department or secretarial department, or you have been a CFO. So in all these experience में आपने सब mediation तो किया ही है ना. You have already been part of so many meetings and resolved so many issues so far. So all of you are competent and capable to become mediator. जी.
Sir, एक
With your permission, if Pallavi ji, I just add to that. It is just taken a cue from the court annex mediation rules. We had a High Court mediation rule, Supreme Court mediation rule. 10 years they have taken reference from that. So sir is very much right that there is no as such mandatory time frame given. So it is one practitioner should not bother about that. Thank you.
सर इनिशियली एक ने अपना केस, अभिजीत सर ने शायद अपना केस कुछ क्वेरी रखी है. May I read it, sir, from the chat?
ये पर्टिकुलर क्वेरी बाद में ले लेंगे.
Okay, sir. Yes, sir. Any participant can unmute and ask their questions if they have for both the
चलो
previous.
ऐसा करिए, आप सौरभ जी को पहले सौरभ जी को कहने दीजिए, उसके बाद मैं भी. I also want to listen to Saurabh ji.
Okay, sir. Now with such a wonderful insightful session, now we proceed towards our second speaker of the day. Next speaker of the day, Advocate Saurabh Bharadwaj. He is a lawyer by profession. He was ex-Director General of Armed Forces and Medical Services in the Ministry of Defense, ex-Recovery Officer, Debt Recovery Tribunal, Ministry of Finance, and have been a great author where he wrote few books, Lockdown Diaries, Pleased to Be Failure, etc. He is a political enthusiast. I warmly welcome you, sir. Now floor is all yours. Now.
Thank you, ma'am. Thanks a lot. That means I am a jack of all trades. I am audible. Am I audible, ma'am?
Yes, sir. Very much, sir. Very much loud and clear.
So actually, in the IP field, I am the new one. I am having a defense background over 20 years. I was a bureaucrat there. So then plunged into the field of lawyers and all that. I was whatever I learned, it's from DRT, Tax Recovery Tribunal. I was recovery officer there. So coming to the today's topic, it is first of all I must extend my thanks to Praveen Jain sir for giving the platform.
सौरभ जी, एक मिनट रोक रहा हूँ. मैं आपको कॉम्प्लीमेंट देना चाहूंगा. आपकी तो उम्र ही 30 साल की लगती है देख के.
Sir, I'm 45. After having 20 years of service, I have taken voluntary retirement.
My compliments to you.
Sir, thank you, sir. Thank you. The same goes to you also, sir. Sir. Coming back, just I want to extend my thanks to Mr. Jain sir and Jiba also, and what a wonderful session it has been so far. And sir has been really enthralling in giving the bilingual lecture and clearing everything from A to Z. I'm nothing more to add in this, but I still would like to speak. See, when I was in DRT and all that, the mediation is basically a settlement. Sometimes parties just come under pressure for mediation and then backtrack. I don't think so. The expert committee still now has given any concrete solutions for that. If the mediation, that legal framework is always required, but whether it will be sustainable in the long run, because mediation encourages the parties of the dispute to reach an agreement by negotiation and avoid adjudication. Adjudication is always very painful for the parties. Is a mode amongst other modes of ADR that allows parties to dispute to reach an amicable settlement. The endeavor behind the whole exercise is to avoid lengthy litigation. Then mediation offers several advantages in the process of insolvency resolution as well, because it is a structured process supposedly where the mediator is responsible for engaging with various stakeholders and sustaining discussions between them. It allows the stakeholders to share their specific concerns and expectations from the resolution plan, whatever may be the stage. It may be at the pre-stage, post-stage. So it gives an alternative platform. Then it cuts through formal, categorization of classes of creditors. Maybe this identifies, particular needs of some vulnerable categories of creditors, maybe the home buyers and all that, who may not be in a position to wait or suffer and an impairment, such as small businesses for whom the debtor is their only customer, maybe for the operational creditors, we can say in that sense. Then mediation often leads to viable commercial arrangements between the stakeholders, which increases the probability of value maximization of the CD. So, in the international context, if we see the case for mediation in insolvency resolution is apparent from its adoption in various jurisdictions, the US, Singapore, Spain, EU, UK, and all that. So they have done it previously quite well in the insolvency field. So we will be following them quite a bit. Now, in this committee setup, which was constituted by IBBI, has made some recommendations on the framework for use of mediation under IBC. Well, couple of things already sir has covered everything, but let's just reiterate something in that. It recommended introduction of voluntary mediation under IBC. Then expert committee considered that introduction of non-adversarial approach. That's a point to be stressed upon. Helps in maintaining cordiality in business relationships and save the CD from the stigma of insolvency while resolving conflicting interest through amicable settlement. Then another catching benefit can be mediation will supposedly aid in reduction of case load in the NCLT, has already been discussed earlier as well. It may or may not, depending upon the intentions of the parties, how much serious they are. Whether the mediator can play a positive role, it is yet to be judged. Then a glance at the recommendations indicates that the committee aims at increasing awareness and building confidence of stakeholders and users in the resolution of disputes by encouraging the use of mediation. And not all scenarios under ABC are fit for resolution through mediation. For example, fraudulent transactions and other avoidance transactions may be excluded, because then there is a portable mechanism which cannot be avoided at any cost, whatever the mediator or process of mediation can be, because people who will get their due have to get their due. Then committee has suggested phased introduction of mediation between the parties while maintaining the sanctity of IBC timelines for various existing insolvency resolution processes. Then the mediation process envisage, it is not just like a one size fits all approach. It may not be applicable to the insolvency resolution process under the code. Then report further elaborates that the proceeding IBC may be specifically excluded from the ambit of Mediation Act and provide adoption of mediation in insolvency disputes. And lay out tailored application. Tailored is mediation is quite flexible. It can be tailored according to, because during my heydays at DRT, I used to conduct lok adalats. So lok adalats is all that when the parties are sitting face to face and all that, whatever conducive things, whatever the best possible alternative solution is, available to them, they will come along with that. So it is basically a tailored application of that. Some laws may be, some rules and regulations may be bypassed if the both parties are ready to come over that. Then role of center and IBBI, regarding the delegation of powers is emphasized, and notifications may be issued in the future. Then committee also proposes the center outline the infrastructure, provision of staff, personal system as already said by sir, e-filing and decide the minimum qualifications of appointments of mediators. It seems to enable IBBI to issue discrete provisions for procedural specifications like the conduct of mediations, including automatic termination of mediation where timelines have expired, because timelines is the essence. You cannot be just sitting cozy in the cozy position and take your sweet time. They have to be ultimately timelines have to be adhered to. Then the process of mediator appointment and removal, nitty-gritties are yet to be finalized. The report also suggests that voluntary mediation is preferable. Of course, mandatory mediation. Mandatory mediation will not serve any purpose because both the parties must be there to come to something. Then selective reference applications by OCs and corporate applications under CRP. Another interesting point is regarding pre-institutional mediations in cases initiated by financial guidance may be explored during later phases of implementation of insolvency mediation framework. It also seeks to include pre-pack, fast-track CRP, individual insolvencies and disputes within the processes, including claim collation process. During claim collation, there are a lot of disputes that arise. People always come along with their sometimes flimsy claims that I owe this and that. So that can be settled for the best possible option. And that's at the level of the COC, exactly. Mediation can be done at any level, supposedly. Then establishment of dedicated specialized NCIT annexed insolvency mediation cell, as revealed by Sir as well, with an independent secretary to administer, oversee and manage the conduct of insolvency mediations under the court. Then as said, key pool of mediators so will always be there, and we are all eligible for that. It is pivotal to avoid any delays in the mediation. IBC has been directly affect the stress status of CD from the time of default, and have the cascading effect on the possibility of its revival. And as a going concern. Going concern is also important because it should not be there that we are just conducting mediation and the company as such is suffering for lack of funds, for lack of service providers, terms and conditions. So going concern is of paramount importance. Then at the end of the my talk, I must conclude that mediation IBC is a game changer. It's a maybe called unprecedented development, which is going to take the law of insolvency and bankruptcy to greater heights. It will act as a leeway for all the stakeholders to try to come to a point where there is ample scope of taking the things to the logical conclusion. Mediation has a major role to play in enhancing the efficiency of insolvency proceedings, resolution of multiple creditor disputes, and achieving consensus among disparate stakeholders. It can reduce delays and cost, both increasing the prospect of successful restructuring outcomes of viable entities and producing a better return for creditors. Then, as often said in various judgments as well, there is a tremendous utility in deploying the services of a neutral third party skilled in mediation techniques, with a mediator able to play the invaluable role of building consensus between the debtor and creditors in the development of a restructuring plan, and to build trust in the process. Trust is of paramount thing, because if there is no trust, there is can't be a role of a mediator. Trust on the mediator as well, and trust between the stakeholders as well. There is a decent possibility that resolution plans agreed during the mediation process may have the potential to be more innovative, and out of the box thinking is going to be, because government had said that after general elections, these committees deliberations would be given into some concrete shape, and that may be a typical CIRP process. It may be a revelation. Then at the last, I must say, role of mediation in helping to achieve creditor coordination and consensus can be especially fruitful in the cross-border settings as well, because when the jurisdiction is outside, then it's very tough to lay your hands on the defaulter. So he can be also brought to the negotiation table. The coordination difficulties among creditors with competing claims in multiple jurisdictions and operating under often very different insolvency regimes are then even greater. So I must conclude my talk, and thanks to the participants to listen to that. Over to Balan sir.
Thank you so much, sir. That was really wonderful. आई एम वेरी लकी टू ज्वाइन द मतलब बहुत ही अच्छा सेशन था. तीनों स्पीकर्स ने इतना अच्छा इंसाइटफुल दिया. नाउ रूम इज ओपन फॉर द ओपन हाउस.
Pallavi, before you start his open house, let me share one practical experience.
Yes, sir.
NCLT में this time-bound mediation has already started. How? I just share it during last 1 month in 2 of my cases. What has happened? Section 7 application in both the cases. Bench is satisfied on the basis of the NSCL registration and all that these are fit case for admission. Now, when the bench is asking the respondent, the corporate debtor, what you have to say, in both the cases, in the meantime, there were some settlement talks. Now, on the hearing or date, CD says that some settlement talks are going on with the applicant. The bench is asking the applicant, yes, what do you say? Yes, sir, talks are going on. On the same very day, the bench, in both the cases, the bench has passed orders that the counsel for the corporate debtor, the respondent says the talks are going on, and counsel for the applicant, the financial creditor, agrees with the talks are going on. Now, after hearing both the parties, this application is disposed of. Both the parties are given 4 weeks time or 6 weeks time, as the case may be in both the cases, to settle it. And if this amount does not get settled, then the applicant is at liberty to come before us and mention for revival of the application. And in that scenario, on the very first hearing, we will admit the case. We will not hear the other party because we are satisfied this is a fit case for admission. So this is now during this period when the application is getting disposed of. Now both the parties have got 4 weeks or 6 weeks as the case may be. So during this 4 weeks or 6 weeks, both the parties have to sit and decide and settle it. Certainly, there is going to be a role of a mediator in between. So here the mediator has got a limited time period. Now this is up to the mediator. If both the parties settle, the company will not go into insolvency, but if both the parties do not settle, the company will go into insolvency. So time-bound mediation has already started. Yes, please.
Thank you so much, sir, for sharing your valuable insight. And now the house is open for the question answers. All the participants can take the benefit or knowledge of a learned speaker by asking their questions. They can unmute themselves and ask the questions.
Not only unmute, they can open their videos also.
Yes, sir. All are requested to open the videos if possible. Sir, someone is saying that I am mediator. If you want to share your views, you can kindly unmute yourself. Yes.
Yes, मदान साहब नमस्कार, कैसे हैं?
नमस्कार, बिल्कुल ठीक जी.
मदान साहब, पिछले 12 साल से तो मैं मीडिएशन कर रहा हूँ हाई कोर्ट में ऑलरेडी. एक तो मीडिएशन में एक्सपीरियंस के अलावा यू नीड 40 आवर्स कंपलसरी ट्रेनिंग, वट एवर नॉलेज आई है. नंबर 2, जो मीडिएशन एक्ट में है वो इनिशियल 4 मंथ्स के लिए दिया है, सब्जेक्ट टू एक्सटेंडेबल फॉर अनदर 2 मंथ्स. जबकि जो कंपनी मीडिएशन रूल है उसमें 3 मंथ्स का है और 3 मंथ्स के बाद फिर अनदर 3 मंथ्स है. Ultimately, both has given the 6 months. The bifurcation is different. Apart from that, the person till then the council came into existence. Mediation center is recognized only the legal aid centers and the high court annexed mediation centers. That is my knowledge. I don't know up to what extent it is correct, so I will ask you to make it correct.
ऐसा होगा, जब भी मैंने कहा था कि जब भी ये रूल्स आएंगे एमसीए से या रेगुलेशंस आएंगी, बिफोर दैट देयर विल बी ड्राफ्ट. Draft rules and regulations will be open for the stakeholders to give their feedback and suggestions. So at that point of time, if you think that such a suggestion to be given, that if it is not there in the draft rules or draft regulation, that the minimum experience, expertise is required, and if somebody is not having that, maybe.
तीनों को यहाँ देश को
प्रवीण जी प्लीज म्यूट कर लीजिए। प्रवीण जी
दो तो वो कागज से लगे था, फाइल में से एक तीनों स्कैन करके भेज दो।
So at that time, it will be open for all of us to give our suggestion. If you think a particular number of hours of practical training is required for the mediators before they act as mediator, the suggestion you may give. But abhi it's a premature, we cannot say it's a report only at this stage.
Okay, because as per the Mediation Act only, the 12A for the commercial contract is compulsory. For others, it is voluntary. It is not compulsory. And apart from that, 40 hours mediation training is must in the High Court as well as Supreme Court mediation, and which is duly recognized under the Mediation Act 2023 also. As far as the timeline is concerned, undoubtedly we can reduce the timeline, but we cannot extend the timeline, because ultimately Mediation Act will prevail. That is my thinking.
Yeah, definitely hoga, because my take is if for to become a registered insolvency professional, you need some training. To become a registered value, you need some training. Similar provisions will be there for the registered mediator also. It will be there definitely.
Sir, I have also
If I-
completed 40 hours
if I may-
mediation training
Sir, if I may
for
add,
becoming a mediator.
Okay, good. Thank you, Praveen ji. So you are fit to become
yes,
mediator.
sir, if I may add answer to this,
Yes.
we have a Mediation Act 2023,
Hmm.
wherein we have a section 38, please refer, and 31. We have a mediation council is yet to come, and
Yes.
the duties and responsibility has been assigned to the Mediation Council of India. Till the time this Mediation Council of India is coming into action, whatever authority and enactments is having the provision with regard to the mediation, even in the with regard to the qualification and the process and all edifices and all efficacies, will run even with the regard to the courts and all. But the moment MCI will come, it has to go by that, and in that only it is the provision is there that even for IP or for any other purpose, MCI will regulate that. They will give a recognition to those institutions, and then further those institutions will give further recommendation or empanelment to the mediation and all. So the imminent efficacy would be like that when we have a MCI in force. Okay. So far, whatever you are saying, sir, it will be according to the respective courts and respective tribunals rules. It will go like that, but we have to wait for the MCI, existence.
इसमें मेरा ये मानना है कि mediation act में there is a provision for exclusion of certain mediation under certain
Yeah, it is then
legislation.
first schedule. Yes, sir.
IBC will be an exception to that. IBC may have its own rules, regulations for mediation.
Obviously, then there would have been an amendment in the mediation.
नहीं,
law,
media will already have provision उसमें for exclusion of certain legislation, certain
Okay,
mediation.
okay. Then it will be definitely
So
there.
that enabling provision is already there.
Yes, then it will definitely.
Exclusion schedule has already been given. So if we didn't, we are not falling under it.
सर अब ये देखिए मीडिएटर तो बन ही जाएंगे, मीडिएशन करना कैसे है बस वो
हाँ.
सोचना। हाँ, how to increase the value, जो preamble में लिखा है ना, maximize the value of the assets of the corporate debtor, वो करना है हमें। How to do that? That should be our main motto.
That's absolutely right.
Right. कोई और क्वेश्चन नहीं है? तभी म्यूट है।
Hello, sir. This is Sangarsh Wak
Yes,
from
Sangarsh.
MP Law College. I'm from second year student, sir, actually.
Okay.
Sir, thank you so much for giving this session for us. Actually, Parna ma'am sent me link to join this session. And we are studying this subject like company and... Hello?
Yes, Sangarsh, carry on, please.
So, sir, thank you so much for these sessions.
Okay, thank you. Thank you.
Sir, I have to ask one question.
Yes,
Anji.
Please proceed.
Sir, one of my company, I'm a student of the law, just now completed my LLB, and there was one company which is its name was ABC, which has been under IBC has been sold to XYZ company in year 2019. But meanwhile, the creditor bank, one of the creditor bank, went into the 2017 in DRT. So in DRT, the order has been passed, but it has been kept as it is. And after 2017, in 2018,
500 members.
in 2018,
Cross हो जाएगा.
the matter has been taken in NCLT, and NCLT had passed the all order, the final order in 2019. And again, after 2 years to 3 years, in 2023, the one of the creditor bank went into the DRAT against the company which is not there in present, means against the ABC company which is not there already in present. And what will be the solution for this, sir, then?
How come this question is relevant for today's webinar? Number one. And number two,
Sir.
an answer to such a complicated situation, certainly I will refrain from giving the answer unless I see the order of DRT as well as NCLT.
Okay. Because
being a
sir,
lawyer,
already
I should refrain from these answer giving to these queries without
Okay.
going into the documents. But yes, prima facie, if the matter is before NCLT, then DRT and DRT have no jurisdiction.
so that only I was saying, because the DR,
moratorium is there, so DRT will not have any jurisdiction. That's in short my answer is.
okay, DRT doesn't have the jurisdiction.
प्रवीण जी, अगर और कोई क्वेश्चन नहीं है,
Sir, whether bankers or financial institutions are comfortable to go for mediation?
देखो जी, मीडिएशन जब भी होगा ना, दोनों पार्टी की कंसेंट से होगा.
Yes.
They are not comfortable, there will not be any mediation.
Yes.
But tomorrow, if they are of the view that mediation is better than taking any matter to NCLT, it's less time consuming, it's least expensive, then certainly they'll also prefer mediation. लेकिन ये सब पता लगेगा जब एक बार mediation start हो जाएगा. We'll see the outcome of mediation, then only we'll be able to give practical answer to this.
Like PPIRP.
Yes.
Anyone is not comfortable.
Yeah, paper provisions.
Paper is not as practical.
Yes.
The cringy elements, sir, would like to, these cringy elements would like to mediation as.
Please, sir.
सूरज जी, आपको दोबारा बोलना पड़ेगा, बार-बार म्यूट अनम्यूट हो रहे थे.
Sir, the cringy stakeholders who just want to pass time will definitely sort out something out of mediation as well. Because willful defaulters, you cannot take care of the willful defaulters at any cost. NPS will be just happening because coercive action will have to be taken against those guys.
But you know, when it will be a time-bound process and NCLT will not be having any right to grant any extension.
Sir.
The only thing is that it can be delayed by 30 days only, not more.
Sir.
Yeah.
Mr. Madan.
Ji Ashok ji.
Inspired, sir.
Namaskar. So, as you know, there are already existing provisions under the RBI guidelines, Section 230-32 of Companies Act. In normal course, the lenders who are PSC banks, they are hardly interested any kind of settlement except the OTS in normal course or the restructuring if they are comfortable as per their own terms and conditions. So, as very rightly the gentleman said, the PCIRP or any other kind of the situation, where there is a discretion of the lenders, nothing is going to happen very seriously. They are only and only interested in CIRP because they know that it is with the consent, it is with the authority of the law. Any decision is being delivered and that is binding on everybody. They just want to get away from the decision making on bilateral basis. In case of mediation, there is a third party, and therefore, to an extent, you can say it is nothing less than the arbitration, and therefore having certain value. But how far they would be willing to go for mediation itself is a very big question mark in my mind.
Sir, बिल्कुल ठीक कह रहे हैं, and committee also knows it. That is why committee has said to begin with is going to be applicable only in case of operational creditors cases and not in case
That
of.
is right. That is right. It will start from operational creditor. They would like to do it with other creditors also. Operational creditor के साथ भी क्या होगा? आपने settlement कर लिया, FC will go to CIRP because the company anyway is in its stress.
नहीं, FC का section 10 तो बिल्कुल almost आजकल possible नहीं है admit करवाना. It has become impossible to get section. But there is very rare, unless you are go here. Section 10 application admission is a very rare.
नहीं, section 10 I'm not talking. I'm talking of section 7 only.
नहीं, 7 में तो फाइनेंशियल क्रेडिटर जाएगा ना फिर.
मैं फाइनेंशियल क्रेडिटर की ही बात कर रहा हूँ कि you see OC is a problem for OC. The default situation happens only when company is in stress. All right. If the company is in stress, even the FC is there. So if OC you settle, FC will have a problem.
So there is a possibility na FC is having 100 crores of loan while the OC is having just 1.25 crores of loan. So if FC like इसको settle करो किसी भी तरह से, मेरा तो 100 crores stake पे है. And he doesn't, that FC does not want a company to be taken to CIRP.
चलो.
So rather than FC may also force the corporate debtor to enter into a settlement with the OC.
So देखते हैं, let us see. Okay. Thank you, my dear.
Thank you, Golji. Praveen ji, close करिए.
Yes, sir.
Thank you so much.
Pallavi ji,
Thank you so much. Now, important announcement for all the participants that this is a weekly webinar, and with the end of this knowledge pack section, I'm sure you all would be looking forward for our next week webinar. To get the information of the webinar, you can contact Praveen sir. He will add you to the WhatsApp group, and you will and to our Gmail group also, and you will be receiving the information of our
also at YouTube channel.
Yeah, you can also revisit this this session through our YouTube channel. Now I would like to thank all the speakers, guest of honors, and all the participants for sparing their time and giving and being the partner of this wonderful session. For formal vote of thanks, I would like to invite Praveen sir for his closing remarks.
Yaar, on behalf of UPA, thanks to all, especially to our guest of honor, Mr. Vikas Kumar, guest of speaker, Advocate GP Madan sir, and IP Saurabh Bardwaj sir, and all our participants, and Pallavi madam. Thanks to once again to all. Thank you. Thanks to all, sir.
Sir, regarding certificates, there's frequent questions regarding certificate. This is just a knowledge sharing platform. We don't issue any certificates, neither CPRs till now. Maybe Praveen sir can consider in future for future webinars.
Thank you, everybody. Very nice interacting with all of you.